In this video, I will summarize each section of the South Carolina Residential Contract of Sale, Form 310, so you can better explain it to your clients. Section 1 of the contract identifies the parties involved in the transaction and who the closing attorney will be. The effective date is the final date upon which a party places the final signatures, and the notice of delivery will cause this contract to be binding on all parties. Lastly, all times stated in the contract shall be South Carolina local time, and time is of the essence concerning all provisions of this contract. Next, you must identify if the buyer or seller has an active South Carolina real estate license. It also asks the buyer and seller to confirm the type of agency they have with their agent. Section 2 asks what the purchase price is, how the buyer will pay for the property, if they are providing proof of funds, and whether this sale is contingent upon the sale of another property. Section 3 will ask for the property address, subdivision, and tax map number. You will also want to make sure you list the appliances that transfer with the sale. You will find language regarding maintaining the property and any personal property conveying in operable condition, including any landscaping, grounds, and any agreed upon repairs or replacements, subject to normal operable wear and tear from the effective date through closing. It also states the buyer acknowledges the opportunity to inquire about many issues such as owners' association, common area, financed equipment, or leases before signing this contract. Section 4 is where you will list the closing date and the name the buyer would like on the deed. The seller is responsible for conveying possession of a vacant and reasonably clean property, free of debris, along with all keys, codes, any remote controls, available documents, and other similar ownership items to the buyer at closing. Section 5 is for earnest money. The total amount of earnest money to be paid is stated on the first line. An amount accompanying the offer is an option on the second line, and the third line or an amount that will be paid at a later date will be entered here, and the date of delivery should be included. You will also identify who will be holding the earnest money. Make sure you tell the other party how the buyer will send the money. It is also the buyer's agent's responsibility to confirm receipt of delivery and notify the listing agent of receipt or any issues with the delivery of the money. If the earnest money is not delivered by the agreed upon date, the seller may terminate the contract by delivering a notice of termination to the buyer. Ensure your client knows escrow law regarding the return of earnest money. You can find that language in the contract. Under all circumstances, including default, the escrow agent will not disburse the earnest money deposit to either party until both parties have executed an agreement authorizing the disbursement or until a court of competent jurisdiction has directed a disbursement. Section 6 is where you will find language regarding the buyer and seller transaction costs. You will also state who will pay any public or private transfer fees. Please note that if no box is checked, this will be the seller's responsibility. If the seller will pay any of the buyer's transaction costs, you will list that amount here. In Section 7, you will indicate if the buyer will have a financing contingency. You will state the type of loan they are seeking and the maximum amount they will finance. The financing contingency expires at closing, which is referred to as the financing period. The buyer shall apply for financing by a specific date, and shall deliver notice to the seller of reasonable pre-final loan approval by a specific date. Ensure this date is not too close to the closing date, as the seller is not required to make any repairs until they receive this notice. If the buyer changes their lender during the financing period, they must notify the seller in writing within a specific number of calendar days. If the closing date agreed upon in paragraph 4 will change, as a direct result of changing the lender, written approval by the seller is required. If a lender declines or fails to approve financing, the buyer shall notify the seller and brokers immediately, and either party may terminate this contract by notice. Please note that any changes to this section must be explained to both buyer and seller, and both parties must approve these changes in writing. Section 8 is for the buyer to have time for due diligence. You will put the date that this contingency will expire. Give your buyer enough time to have an inspection, provide the seller with repair requests, negotiate repairs, then move forward with an amended contract or terminate the contract. If you do not have an amended contract or terminate the contract before the expiration date and time, the contract will become an as-is sale. For the buyer to terminate the contract successfully, you must provide both the termination fee and the termination paperwork, Form 313, before the expiration date. The buyer will pay this fee directly to the seller. Any extension to this date must be in writing. If you are submitting a repair request, make sure you list all repairs you are seeking at the same time. Once you send the repair request to the seller, you cannot ask for additional repairs. If the buyer and seller agree on the repairs and sign the addendum, Form 525, you have an amended contract. Section 9 states the buyer will use a licensed and insured inspector, inform the seller of the date and time of the inspection, and the seller will allow the buyer to have a final walkthrough within 48 hours of closing. The seller also agrees to keep the utilities on. If the utilities are not on, and the seller will grant the buyer permission to turn them on, you would check this box. Section 10 is where you will indicate if this sale is contingent on the home appraising at or above the purchase price. If this contract does have an appraisal contingency, and the home does not appraise for the purchase price or higher, the seller must lower the purchase price to the appraised value, or the buyer can terminate the contract. Section 11 is where you will indicate if this sale is or is not contingent on a clean CL 100 report. State who will order, pay for and deliver the results by checking these boxes. Also, add the minimum amount of days you would like before closing to receive this report. If the findings reveal damage, the seller must correct the issues. If the seller is unwilling to correct the issues, the buyer can take these steps: accept the property's condition, negotiate repairs, or terminate the contract. Section 12 refers to insurance, survey, title, etc. It is recommended the buyer have these items completed prior to closing. The buyer agrees to have insurance effected on the day of closing, and the seller can cancel their policy. If allowed, the flood insurance policy can be assigned to the buyer. Section 13 states all agreements survive closing. Section 14 will indicate if a home warranty will be provided. List who will order the policy, how much they will pay, and the name of the company. Section 15 tells you what will happen if the property is damaged while under contract. Parties have 5 days after notice to terminate the contract. Section 16 will indicate if a property disclosure has been provided to the buyer. Please note, if the disclosure needs to be updated, because a new material fact or inaccuracy has been discovered, the seller must make the correction and deliver a new disclosure to the buyer as soon as possible. This applies even if you are already under contract. Section 17 refers to the documents needed if the home was built before 1978 and may have lead-based hazards. Section 18 covers sensitive topics such as sexual offenders or crimes that may have occurred on the property. This section informs the parties that it is their responsibility to research this information. Section 19 asks if the person holding the earnest money may or may not have an interest-bearing account. If you check may not, it is your responsibility to confirm the person holding the money does not have an interest-bearing account. Section 20 talks about taxes and parties agree to comply with all laws. Section 21 states that all parties acknowledge that the contract expresses the entire agreement and that no other agreements exist to modify these terms. Basically, if something is not listed in this contract, it does not apply. Make sure all changes to this contract are in writing and dated. Section 22 discusses adjustments and the items that will be prorated at closing. We also find language here regarding special assessments. Special assessments approved prior to closing shall be the responsibility of the seller. Special assessments approved after closing shall be the responsibility of the buyer. Ensure you are aware of any modifications needed to this language and inform your client's attorney so they can prepare an amendment. Section 23 talks about default by either party. Section 24 talks about mediation, if needed, and how to start that process. Section 25 also states that all agreements must be in writing, and if it is not included in this contract, it will not apply. Section 26 lets the parties know that the broker gives no warranties on the items listed here. Section 27 refers to the broker's compensation. Any addendums or attachments to this contract must be listed in Section 28. The most recent change is what will be enforced. Any language on an addendum will supersede what is in the contract. Section 29 goes over what notice and delivery mean. Section 30 addresses a few items such as wire instructions, cameras on the property, that all parties have copies of all documents and have sought legal counsel. Section 31 is where the expiration of the offer will go. All parties will initial all pages and sign at the end. The listing and buyer agent details should also be included. Here is where you will define how the termination paperwork and fee will be delivered. It is especially important for this section to be completed. I also like to include this language in detail in a separate addendum. If I am representing the buyer and there is a termination fee, I think it is important for all parties to understand how that fee will be paid if the buyer elects to terminate the contract during the due diligence period. Here is an example of the language. This should be adjusted per scenario. Seller to provide buyer with the seller's Venmo instructions within 3 days of this contract being fully executed. Buyer will pay the termination fee on or before the due diligence expiration date, if the buyer elects to terminate the contract. Buyer's agent will email the termination forms 313 and 518 to the listing agent on or before the due diligence expiration date, if buyer elects to terminate this contract during the due diligence time period outlined in the contract of sale. This language is clear and all parties know how the paperwork and fee will be sent if the buyer decides to terminate the contract. Also, make sure you are familiar with the differences between Forms 313 and 518. 313 is a unilateral termination form and only requires one party's signature to terminate the contract effectively. 518 is a termination agreement that addresses where the earnest money should go and all parties must sign this form to be considered executed. If you represent a buyer, and that buyer wishes to terminate the contract during the due diligence time period, make sure you always use Form 313. Also, remember, the termination fee is only owed if the buyer is terminating the contract for due diligence. If the contract needs to be terminated for any other contingency, the fee is not owed. An example of this would be financing or CL 100.